Welcome to the deep dive.
Yeah.
You've definitely sent us down a fascinating rabbit hole this time.
Yeah, we have.
We've got a pile of online discussions here, all circling around the legal stuff involving Justin Baldoni, Jennifer Abel, and Stephanie Jones.
That's right. That whole situation.
But what's really jumping out, and what we're going to unpack, is Bryan Freedman's approach. You know, the lawyer for Baldoni and Abel.
Freedman, yeah. What about him?
Well, his intense focus,
Yeah.
almost laser-like on this subpoena, it seems odd to some people.
Okay, yeah, I've seen that commentary too. We've looked through what people closely following the case are saying, and there's this real sense of confusion.
Confusion about what exactly?
About why so much energy, so much oxygen is being spent on the subpoena itself. Instead of dealing with the pretty serious allegations against Abel that are just kind of hanging there.
Like the conspiracy claims against her old employer.
Exactly. Conspiracy, allegedly taking company secrets, data theft, even trying to poach clients. I mean, these are substantial accusations.
Right. Not minor quibbles.
Yeah.
So the big question floating around is why focus on the process, the subpoena, and not the substance?
Precisely. It does feel like a bit of strategic maneuvering, maybe, like shining a spotlight over here while the main thing is happening over there.
Yeah, misdirection. And it seems the core issue people are pointing to is the lack of a clear, strong denial from Freedman about those specific claims against Abel.
That's a key observation, definitely. From what we've gathered in these discussions, there hasn't been a direct, this didn't happen regarding the substance of those accusations.
Which feels significant.
It does. And that lack of direct rebuttal fuels speculation, doesn't it? People start thinking, well, maybe they can't directly deny it.
So the focus stays locked on the subpoena instead.
It keeps the conversation there. And naturally, that leads people to theorize about the strategy behind it.
And one theory that keeps popping up is this idea of Freedman acting more like a PR lawyer here.
The public relations angle. Explain that a bit.
Well, the idea is maybe the main goal isn't purely legal victory in the traditional sense, but more about managing public perception.
Shaping the narrative.
Yeah, shaping the narrative, trying to stir up public support, maybe trash the opposition a bit, making noise.
Okay, I see how that fits. If that's the angle, then hammering away at the subpoena makes perfect sense, doesn't it?
How so?
Because it's a fantastic distraction.
Yeah.
You argue about whether the subpoena was valid, how it was served, was it permissible.
And meanwhile, no one's talking about the alleged stolen data or conspiracy.
Exactly. You shift the focus away from potentially, let's say, uncomfortable facts about what Abel might have done or the overall legal strength of Baldoni's case.
It's a classic playbook in high-profile cases, right? Control the story.
Absolutely. Influence the narrative by controlling what people are even discussing.
And speaking of Baldoni's case, there's also chatter suggesting his legal position isn't exactly rock solid.
Yeah, some observers are pointing to what they see as relatively strong arguments in the motions to dismiss his first amended complaint, the FAC.
Right. And didn't the judge deny his request for more time pretty quickly?
That too. The swift denial for an extension. It didn't exactly signal smooth sailing ahead, legally speaking. At least that's the interpretation.
So maybe the PR push is partly to compensate for potential legal weaknesses.
That's certainly one plausible reading of the situation. If the legal ground feels shaky, you might try to win in the court of public opinion.
And if Baldoni's position is seen as tricky, what about Abel's? The commentary seems even more pointed there.
Oh, absolutely. The general consensus seems to be that Abel is in a particularly tough spot.
Tougher than Baldoni.
Potentially, yes. There's this sense that regardless of how a trial might end, the information allegedly on her phone described as damning puts her in a very difficult position personally and professionally.
Implying consequences beyond just the lawsuit itself.
Right. That the fallout could be significant no matter the legal outcome.
Okay, so let's connect that back to the subpoena focus. How does Abel's difficult position relate to Freedman hammering the subpoena issue?
Well, if the evidence against her is strong, particularly if it's based on her own words, focusing on how that evidence came to light via the subpoena becomes a way to try and undermine it.
Sow doubt. Create ambiguity.
Exactly. Maybe even fuel a few conspiracy theories about how the information was obtained. It's a tactic to potentially pressure the other side, or at least muddy the waters for the public.
Makes sense. Because directly denying the allegations seems tough, especially if, as reported, they're based on her own text messages.
That's the crux of it. The sources mention text messages where she supposedly, and I quote loosely here, bragged about stealing confidential documents.
Wow, okay. If that's documented.
If that's documented in her own words, yeah, it's incredibly hard to just say, nope, didn't happen. How do you credibly deny your own texts?
So what has the response been then from Freedman's side on those texts?
From what's been discussed, the main line seems to be that the messages were, quote, taken out of context and cherry-picked.
Okay, the context argument.
Right, but notice that's not quite the same as denying the content of the messages, is it? It's more about framing, trying to lessen their impact without directly refuting what was said.
Interesting distinction. It's all about managing the narrative.
It certainly appears that way, and this leads into another point people are discussing. The sheer amount of media Freedman seems to be doing.
Right, he's been quite visible, hasn't he? Lots of interviews, statements.
Which is, a bit unusual for lawyers deep in complex litigation like this. It definitely raises eyebrows.
Why? What are people inferring from that?
Well, it fuels the PR lawyer theory again.
Hmm.
Does it signal confidence in the legal case itself? Or is it more of an attempt to fight the battle in the media, a trial by media strategy?
But focusing so heavily on PR, on media appearances, does that carry risks for the actual legal case?
Oh, absolutely. That's a major concern highlighted in these discussions. There's a real danger of dropping the ball on crucial legal deadlines and procedures.
Like what?
Things like responding to interrogatories on time, filing an amended complaint by the deadline, the actual nuts and bolts of the lawsuit.
And given the judge already denied that extension.
Exactly. It suggests the judge might not be inclined to grant much leeway if deadlines are missed because the focus is elsewhere. Well, that could have serious consequences.
Like the judge imposing sanctions.
Could be. Or disallowing evidence that's submitted late, refusing to allow further amendments to the complaint. Basically, damaging their ability to actually argue their case in court.
So the PR focus could backfire legally.
It's a definite gamble. Prioritizing the external narrative over the internal court process is risky business.
There was also that detail about Freedman calling the subpoenas phantom subpoenas. What was that about?
Yeah, that terminology caught people's attention. It's seen by some as another PR tactic, maybe an attempt to sound dramatic or imply something nefarious without much substance.
Like trying to paint the other side as shadowy or unfair?
Pretty much. Some found it a bit unoriginal, maybe borrowing from other high-profile cases.
Speaking of which, people are drawing parallels, aren't they, to similar distraction tactics used elsewhere?
They are, pointing to cases where focus was shifted onto side issues, maybe personality clashes or procedural fights, to draw attention away from solid, potentially damaging evidence, like the Depp trial was mentioned as an example by some commenters.
Interesting. Now, adding another wrinkle, there's this claim that Wayfair and Baldoni actually knew Jones had the phone with these messages.
Right. That's a potentially significant point being raised. The suggestion is they weren't totally blindsided by this.
How so? What's the evidence for that?
Well, there's talk that they even flagged Abel's old phone number in their own internal communications, like when onboarding new people.
Implying they knew that number and potentially the phone associated with it might contain sensitive stuff.
That's the implication. If they knew Jones had the phone and were aware of potential issues with Abel's old communications before the subpoena, it kind of changes the whole narrative around the subpoena being some shocking event, doesn't it?
It certainly complicates the picture of surprise or outrage. Suggests maybe they anticipate this information might come out eventually.
It raises questions about the timeline and what was known when.
And then there's this other, potentially very tricky issue. The idea that Freedman himself might become a fact witness.
Ooh, okay. How would that happen?
The theory is that because he was involved very early on, he might personally have emails or knowledge directly relevant to the facts of the case, not just as a lawyer, but as someone who knows things.
And if he's a fact witness?
Well, generally, you can't be both the lawyer arguing the case and a witness testifying about the facts. It's a conflict.
So he might have to withdraw his counsel.
It's a possibility that's being floated.
Yeah.
Which obviously would throw a major wrench into their legal strategy. Huge complication.
Wow. Yeah, that would definitely add another layer of uncertainty.
And just as a bit of extra context, some people brought up Freedman losing another case recently. Something about a reality reckoning case.
Yes, that was mentioned briefly, sort of as background on his recent track record. Not directly related, but part of the overall picture observers are piecing together.
Okay, so wrapping this all together, it feels like the dominant view, filtering through all these online discussions, is that Freedman's heavy focus on the subpoena isn't accidental.
No, it seems very much interpreted as a deliberate, strategic choice.
A choice designed primarily to distract.
Yes, to divert attention from the core allegations against Abel. the conspiracy, the data theft, and maybe, just maybe, to bolster a legal position that might have some weaknesses.
And it's worth stressing again, based on everything we've seen discussed, this strategy hasn't included a direct, forceful denial of the substance of those text messages or the main accusations.
That point comes up again and again. The focus is on context, on procedure, on the subpoena, but not a flat-out "she didn't say that" or "she didn't do that," at least not that observers have picked up on.
Which really leaves us with a final thought for you, the listener, to chew on. Considering this approach, which seems so heavily weighted towards PR and narrative control, what does that suggest about their confidence in presenting a strong legal defense in court?
Yeah, does this intense focus on the public story potentially signal less confidence in the actual legal arguments and evidence they can bring forward when it really counts?
It's that tension, isn't it, between the courtroom battle and the public relations war. A really complex situation to watch unfold.